you very much for the introduction. Welcome, everybody. As you now have my entire bio, I think we'll just go right into the lecture. As I mentioned, or has been mentioned, today's lecture is on judicial review. What I'm hoping to accomplish here is three things. One, I want to explain the concept of judicial review. Second, I want to explain the origins in American history. It's a fairly interesting story. It mixes some politics, some law, a little history as well. Hopefully it'll be useful to you. And then finally, I want to talk about how this concept in American law has helped shape the United States and, to a certain extent, the relationship between democracy and the judiciary. Now, we've got quite a few things to do, and I should also mention we are going to have a decent number of concepts that may or may not be familiar to you. To help remedy this, you have the handout in front of you. It's about 2 pages. They're numbered. I will mention the number and the term when they become important within the lecture, and hopefully this will help with any gap in your knowledge. And then finally, I need to mention that I do have a habit of speaking quickly in front of large people, so if I start to speak too quickly or if I miss something, just raise your hand, look confused, I'll come back and try and explain it again. So now we've got a decent amount to cover, so let's begin. Part 1, what is judicial review? Now, judicial review, simply put, is the doctrine under which the judiciary reviews and possibly invalidates orders brought by either the legislature, your Congress, your National Assembly, or by the President, the executive. Basically what you're saying is the court is actually saying to the executive or to the legislature, the law you passed is illegal and it cannot be enforced. Now, I need to point out that this is not the same thing as a court in its normal functions, the judging a case, determining whether certain elements of a crime have been met. Nothing like the roughly 9 million episodes of Law and Order that you see run on a continuous loop around the world. That's the normal thing. This is a step above. What the court is not saying here is, the prosecutor, you have failed to prove your case in this murder trial. He is saying the law itself that you have brought cannot be recognized. Person's free to go. Now, this is a very significant power. Not only are you basically undercutting the executive and the legislature by saying this, you're telling them you did your job wrong and you will do it correctly. And it's worth bearing in mind that the court lacks the traditional powers of government. It doesn't have tax powers, it doesn't have revenue powers, and it doesn't have either a military or a police. It's dependent on the other branches of government for this. So for them to actually have achieved this is pretty remarkable just from a standpoint of realpolitik. Now, I need to also mention that there are limits. Specifically, you need 2 things. First, a court cannot claim power over an issue that it isn't specifically empowered to talk about. Let me give you an example. If you have a tax court and it specifically covers tax law, this court cannot make pronouncements about whether or not a criminal law is valid under a constitution. It's limited to tax. It can declare tax law invalid for various reasons. Can't touch the criminal law. Similarly, in the United States, we have the federal system. You have both the state courts and the federal courts. A state court, say the appeals court in New York or the Supreme Court of Arizona, they can't actually decide whether or not a federal law is unconstitutional. That'll move it to the federal courts, and then they'll decide under their power. Second thing that you need to have is you have to have a basis of authority for your removal. You can't just basically say, I don't like the law. It's gone. You have to remove it based on a higher authority. And the most common solution is, this law violates the Constitution of this state or of this country, therefore it is invalid. You can't just say, no, don't really like it. It has to have a reason, and it has to have a higher authority. So let me give you an example of this. Back in 1997, when the internet was very young, the United States Congress passed a law called the Communications Decency Act. This act was to ban, quote, indecent images and words from the internet. Very fancy way of saying pornography. And yes, for all of you younger than me, there was a time where people in government thought they could actually pass a law to stop people putting pornography on the internet. Very naive time, very naive. Anyways, the law violated the First Amendment of the United States, which specifically says, Congress shall make no law abridging the freedom of speech. Previous court cases had determined that pornography was covered by freedom of speech. Therefore, in the case of ACLU v. Reno, the Supreme Court struck down the Communications Decency Act because it violated the First Amendment. That, in a nutshell, for you, is an example of judicial review in action. Now, I want to stop for a second because a couple of you looked like a little surprised that we're talking about this, because it seems fairly uncontroversial. And in the present day, you're absolutely correct. Many countries in the world now have some form of judicial review. An incomplete list of this will be France, courts in England and Wales, Sweden, Australia, Hong Kong, and even the Korean Constitutional Court, which I'm remembering correctly, it's Article 107 that specifically gives judicial review to the Constitutional Court over matters of constitutional law, constitutional questions. Now, this last point is actually very important. Specifically, you have written it into your Constitution. All the other countries I've mentioned as well have written it into their Constitution. So this is not a power that has been created out of whole cloth. This is not the same thing as what happened in the United States, where we get judicial review. This was not planned by the people who wrote the Constitution back in 1787. Nobody really had an idea of this. What happened was a very famous case, which you will find at number 2 on your handout, named Marbury v. Madison, which was decided in 1803, which brings us now to the second part of the lecture. How did we get to judicial review? Now, before I can go into the details of the case, we have to talk a little bit about the history and the background. Specifically, we need to talk about the election of 1800, which is at number 7 on your list. I've also included the parties, the main political parties of the time, on the second page at 11 and 12. But the election of 1800, very famous, the Revolution of 1800, pitted John Adams and the Federalists against Thomas Jefferson and the Democratic Republicans. You also hold them known as Republicans, but long story short of it, the Federalists get killed. I mean, they get absolutely slaughtered in this election. They lose the Senate, they lose the House, they lose the presidency. This really does mark the beginning of the end of the Federalist Party, for reasons that are a little outside of this lecture, but they make quite a few mistakes, they make quite a few tactical errors, and basically the idea of the revolution creates a very great gap between what they imagine America to be and what most of the country imagines to be. And you'll notice in the party section that they're typically declared dead as a party in 1816. They stay around a little longer, but effectively that's true. So the Federalists are destroyed. They were previously the dominant power. They had control of all three branches in 1798, and in 1796 they are slightly associated with George Washington. Excellent image to have if you're in American politics. But 1800 comes and they're all out of a job. So what do? Now, I've mentioned in the handout they are the party that believe in a strong centralized government. And one of the things that necessarily entailed was a lot of government positions. So there is a gap between when the new Congress is sworn in and when they are effectively fired. And so they take this time, colloquially known in the United States as the lame duck session of Congress, and they pass the Judicial Act of 1801. That's number 4 on your handout. The basic point of that, in kind of raw political terms, is to give jobs to the Federalists, to pack the courts, to give them as many positions, to have some influence, because, to be blunt, some of them also understand that their ideology is simply dying and that they're losing ground too quickly to recover. So the best way to handle this, give some people some jobs that are not subject to an election in 2 years. They expand the court from the circuits from 3 to 6. They add, I believe, 42 justices, federal judges, and 42 justices of the peace and 16 judges in this act, including one justice of the peace to a William Marbury, whose name will be coming up shortly, who was given the job of Justice of the Peace in Washington, D.C. So they pass the act. The Senate immediately passes all of the appointments, and the appointments go to the Secretary of State to deliver. Now, this is a key point in this lecture. The appointments actually have to be delivered to the person for the commission to take effect. Now, because of the time frame, there's just not enough time to do everything. So some of the judges, they get referred to as the midnight judges, are not delivered. And this is a great irony of this, Chief Justice Marshall, who's also serving as Secretary of State at this point as well, is the person who's supposed to deliver all these things, and he can't get them done in time. So he leaves them for James Madison, who's going to be the new incoming Secretary of State, to finish delivery, so that they can start their jobs as Justice of the Peace and of judges in the various new circuits they've created. Now, obviously, the Democrat-Republicans are not happy with this. They just won the election, and they're shocked by this action. So, as soon as it's possible, they get into power. They do everything in their power to undo this. They pass a second act trying to nullify the Judicial Act of 1801, and they also, and this is the key, refuse to deliver the remaining appointments. Now, without the appointment, I've said, there's no commission. So I mentioned William Marbury, the Federalist supporter from Maryland, who's supposed to be the Justice of the Peace in Washington, D.C. He doesn't have a job, and he's not happy about it. So he goes up to the Supreme Court under, and this is number 6 on your handout, under a special judicial action called the writ of mandamus. It's a fancy Latin way of saying, I want the court to order somebody to give me something, specifically the government to give me my commission. And that's where we run into Justice Marshall, now as Chief Justice Marshall, on the court to decide Marbury v. Madison. Now, I mentioned all of this politics in the background for a reason, and it's because this case obviously has more importance than some random commission of Justice of the Peace. Marshall is getting incredible pressure from two sides. From his own side, the Federalists, they want him to appoint, he wants them to demand that he deliver the commission. He wants them, the Federalists want Marshall to order Madison to give them the commission to Marbury. They also want him to expand the power of the court, essentially, because this is the last refuge of the Federalists. On the other side, though, you have the Democratic Republicans, party of tomorrow. They've just been swept into office, doesn't look like they're going anywhere, and they also have power over his court. So he's got a very fine balancing act to do. He wants to advance his Federalist beliefs. He also knows he can't do it in the face of such popular opposition from the Democratic Republicans. And so, with this in mind, he has to figure out how to deliver a verdict that he wants, that won't be ignored by the court, by the federal government. And that's where we get the decision of Marbury v. Madison. Now, if you go back to your sheet, section 2, point 2, you'll see the three questions that were raised in the case. Now, the important thing to note is this is the order in which Marshall delivers his opinion on. So question 1, does Marbury have a right to the commission? And Marshall says, of course. There was a law passed. He was appointed a commissioner by the Senate. He has a job. He is a justice of the peace of Washington, D.C. Second question, does the United States law give Marbury a way to get justice on this? Is the writ of mandamus a valid legal claim under law? And Marshall says again, yes, of course. This is an obvious question. There's no question about this. And so at this point in the opinion, you think, well, Marshall's going to dare Thomas Jefferson to ignore him because he's going to demand that that Madison give Marbury the commission. Third question, is the writ of mandamus to the Supreme Court the correct legal remedy? No. And this is the very difficult part of the case. If you guys can get this, you are smarter than the average university student and a good number of law students in America, and I really hope I can deliver this. The writ of mandamus, as you note on your handout, was given to the court, was this power to hear these cases as an original jurisdiction. This is a very fancy way of saying, that's number 5 on your handout. Original jurisdiction is a legal term meaning that the first place you go to is the Supreme Court. Rather than going through the lower courts, the District Court, the Court of Appeals, it's the Supreme Court, you go directly to the Supreme Court. And the 1789 Judicial Act increased the number of things that the Supreme Court had original jurisdiction over. Originally, in Article 3 of the Constitution, there's just a list. And so what Madison says is, I'm sorry, but this is the incorrect place for you to give us, to have your opinion heard. You have to go to a lower court. And the reason is because Congress passed an illegal law. They increased our federal jurisdiction, and they do not have the right to do that. Under the Constitution, this is our limited powers, and Congress can't increase them. Therefore, this law is invalid. Now, this is pretty impressive. He then goes further and says, basically, whenever the Supreme Court finds a law to be unconstitutional, they're going to find it invalid. And the famous quote of it is, "It is emphatically the province and duty of the Judicial Department, Supreme Court, to say what the law is. Those who apply the rules to the particular case must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide the operation of each." To say what the law is, the very basis of judicial review. Now, I want to pause for a moment and just point out the political genius of this decision, because it is just superb. Marshall has managed to do the impossible. He has expanded the power that the Federalists want, but at the same time, he has delivered it in such a way that the Democratic Republicans can't be angry with him. How could they be? Marbury doesn't get his commission. And he actually struck down a law that gave his court more power. So what could possibly Thomas Jefferson complain about in this decision? He got everything he wanted. But in doing so, Marshall has just greatly expanded the power of the court. He suddenly has all these new powers, and as you'll see, he's going to use them. And that's exactly why he ordered the questions the way he did. It's why it was, of course he has a job, of course he has the right to ask for the job, but he can't ask me. Looks like he's obeying the political will of the Democratic Republicans, but he's actually expanding the power at the behest of the Federalists. I want to tell you that this is brilliant work. If there are any politicians or aspiring politicians in the audience today, this is the gold standard. You want this moment for your own career. Now, another point to make on this is that this Constitution is only 16 years old at this point. There are people in Congress who wrote the thing, who are reading this opinion and going, we didn't say that. This is not what we have actually written down in Congress. In fact, James Madison, the guy who refuses to deliver the commission, Secretary of State, he's also known as the father of the Constitution because he wrote so much of it and he brokered so many deals back in 1787. So they're stuck, though, because he's rendered this decision. They've gotten pretty much what they wanted, and they're not sure how this is going to play out. So basically, now we're on to point 3. So what is the result of this? Well, in the United States, the most immediate result is the Supreme Court suddenly becomes a co-equal in the government. Prior to this, your main concern was about whether or not the judiciary or the Congress would have the most power or the executive would have the most power. And this is actually where the main divide between the Federalists and the Democratic Republicans occurs at the federal level. Nobody actually thinks much about the court. The main concern at that time was making sure that it would be independent. And so the two main things that they did was, one, they split the power. Congress approves judges, but the president appoints people, nominates them to be considered for the Supreme Court and the various courts created later. And they're given a lifetime term so that they're not beholden to anybody. They're simply there to do their job. This, by the way, the lifetime appointment, very useful to Marshall when he makes the opinion, because the only route for the Democratic Republicans to remove him is by impeachment, and that's almost impossible. Now, on a second level, though, you're going to see this power greatly increase the federal government over time. I mentioned that the Federalists also have an interest in a strong national government, and the technique that Marshall uses in creating judicial review is going to later expand the power of Congress over the states and over various things. And as this power becomes more used, it develops its own kind of pedigree and acceptance. The Supreme Court starts to take more bolder action. Famous examples will be the desegregation of American schools in Brown v. Board of Education. Although, ironically, this overturns an earlier opinion that allowed segregation in American schools and public facilities. The 1960s, you'll see a number of cases where the defendant rights, the rights of the accused, are greatly expanded. And freedom of speech, obviously, being the most probably salient one that's expanded over time. And on this point, you also get to the larger consequence in the political sense of judicial review, which is by having the court say whether or not a law violates the Constitution stops being so much a political document and starts becoming a legal one. And this has a very, very important effect for you. Now, I mentioned freedom of speech and freedom and the rights of the accused. These are things that don't get you elected to Congress because they're typically not popular people when you're being accused of a crime. But they're very necessary in order to have a functioning society, a free and open society. So if you left interpreting the Constitution solely to the legislature, there's a very strong chance that the freedoms that you now experience, that you enjoy, they're not going to exist. The political will to create them is just not going to be there, and it will be too easy during periods of extreme distress to get rid of them. However, this also does raise an issue for you concerning democratic governance in a larger sense. And that is the best argument against judicial review is, why is the court the best place to decide democratic questions? Why is it not the place of the legislature, of the duly elected government? Because they actually do better reflect the current opinion of people. And a certain degree, having the judicial review as a safeguard also results in Congress getting lazy. I mentioned earlier the Communications Decency Act. It was struck down by the Supreme Court for violating the First Amendment. Pretty much everybody who voted for it knew it was illegal. They knew it was unconstitutional, and they knew it wasn't going to survive. They voted for it, however, because they knew the Supreme Court was going to fix their mistake, and that they could look popular to people saying, oh, I tried to stop bad things on the internet, but the Supreme Court overruled me, so it's their fault. If the road ends in your Congress, the thought is then you're going to get more thoughtful legislators. You're going to have congressmen who think deeply about the issue, whether or not it's actually going to result in a negative for the country, for political freedom, for political expression, and a democratic society. Now, obviously being a lawyer, I come out on the side of the courts. They're not being pressured by the various passions of a political moment. They're trained to do it, and they have a genuine interest in preserving your political freedoms. So, I guess now, in conclusion, what do you take from all this? From your American history standpoint, a couple things that I hope to stress for your class is, one, just how genuinely disorganized the early republic was in the United States. We have a bad habit in the United States of saying the founding fathers and thinking that it was a bunch of people who got along great, and they formed this perfect document with no changes whatsoever. Couldn't be farther from the truth. They hated each other. They fought, they backstabbed, they had affairs, they shot each other. It's a pretty good soap opera. And to not mention this really is, it undercuts the idea of just how difficult it is to create a democracy and create a political dialogue. From a legal foundation, I hope you understand, one, just how genuinely important and powerful judicial review is, and just how, what a break it is from traditional law, and that we're living in a very, very unique era where a court has this much power without the ability to tax somebody, without being able to order troops to do something under their direct control. It's definitely a break from most of human history. And then finally, on the larger political sense, I hope the just basic issues that I've mentioned now, the pros and cons of having the judiciary safeguard your freedoms, also means you're not as directly participating in what those freedoms are supposed to mean, what they're supposed to have, has an impact on your life, and whether that makes it a less complete democracy.
자, 감사합니다.
Thank you. You're too kind.